Hello and welcome. My name is Siti Nurshahila binti Nordin, and in today's presentation, I will be critically analyzing an AI generated answer to an intellectual property law question regarding Getty image US versus stability AI. The question concerned whether stability AI authorized use of Getty image marks, specifically its watermark on synthetic image generated through AI tools like Stable Diffusion and Dream Studio constitute trademark infringement. Furthermore, we will examine whether Getty image is entitled to injunctive relief and damage. For the purpose of this analysis, I have selected the AI generated answer provided by ChatGPT, and I will offer a detailed counter argument and constructive feedback. My goal is to identify where the AI analysis could be improved and to present a more robust legal argument. The AI response is generally structured well, providing a solid framework for understanding trademark infringement in both the US and UK legal context. However, there are several areas where the analysis could benefit from deeper legal reasoning, a more thorough examination of case law, and a stronger application of trademark principles. In the next few minutes, I will talk you through these areas and present my critique supporting my argument with relevant legal principle and case law. The AI answers start by outlining the legal framework in both the US and the UK, specifically focusing on trademark infringement law. In the US, it correctly references the Lanham Act, which governs trademark infringement. The AI accurately identified the element needed to establish a claim for trademark infringement, such as ownership of a valid trademark. The use of the mark is common and the likelihood of confusion. Similarly, in the UK, the Trademark Act 1994 is cited as the governing statute with similar elements for infringement. While this is a good starting point, there are several gaps in the AI analysis that I believe need to be addressed. First, the AI fails to engage with relevant case law that will provide a deeper understanding of how trademark infringement has been handled in similar circumstances. For example, in the US, one key case that should be discussed is in the Getty image versus stability AI itself, as this case is at the heart of the dispute between the two parties. The court ruling on AI generated content and the fair use doctrine will be highly relevant. The fair use doctrine could potentially provide a defense for stability AI, particularly if it is found that the use of Getty's watermarks was transformative in nature and did not harm Getty's market. This was an important consideration in other AI-related copyright cases such as Authors Guild versus Google, where the court ruled the Google's use of copyrighted material for indexing was not infringing due to the transformative nature of the use. Additionally, in the UK, the AI does not explore relevant cases like L'Oreal SA versus eBay, which address the role of online platform in the infringement of the trademark rights. While this case primarily dealt with counterfeit goods, it is still relevant in the context of AI tools facilitating the creation of synthetic image. The UK courts have considered whether platform enabling trademark infringement could be liable, and similarly, stability AI could be held responsible for its role in creating and distributing AI-generated image that feature Getty's watermark. Furthermore, the AI treatment of the likelihood of confusion is somewhat superficial, while it rightly acknowledges the importance of consumer confusions. It does not provide enough depth on how this concept applies in the context of AI-generated image. The AI mentioned that the watermark could create confusion among consumers, but it should differ into factors such as actual confusions. In trademark cases, evidence of actual confusion is highly persuasive. For instance, if consumers have mistakenly believed that the AI-generated image were endorsed by Katie, this will be a significant factor in proving infringement. The AI should have discussed whether they are reports or evidence of consumer confusion, which will strengthen Getty's case. Moreover, the degree of care exercised by consumers is another factor that could affect the likelihood of confusion. The AI suggests that if the watermark is prominently displayed, consumers may confuse the AI-generated image with authentic Getty content. However, it does not consider that consumers of synthetic image might be more discerning, especially in industry like advertising or digital art, where AI-generated content is more commonly used. Consumers in these sectors are likely to be aware that AI tools are being employed and may confuse the image with traditional photography from Getty. The AI also touches on the defendant intent, briefly mentioning the stability AI could have acted in bad faith if it knowingly used Getty marks. However, the analysis could go further by exploring whether stability AI action could be seen as intentional or inadvertent. In cases of bad faith, court often examine whether the defendant knew or should have known that their action would lead to trademark infringement. The AI should have explored whether stability AI had any prior knowledge of Getty's watermarks or whether it made efforts to avoid such infringement. This will provide a fuller picture of stability AI intent, which is a critical element in trademark infringement claim. The AI discussion of injunctive relief and damage is an important part of the analysis, but it could be expanded. The AI correctly mentioned that if trademark infringement is found, Getty Image could seek injunctive relief to prevent further infringement. However, it does not explore how Getty will need to demonstrate irreparable harm in order to secure an injunction. Irreparable harm is one of the key elements courts consider when granting injunctive relief, and Getty will need to prove that the continued use of its watermarks in AI-generated image could harm its reputation or business in ways that cannot be compensated with monetary damage alone. The AI could have provided a more detailed analysis of how the nature of Getty's business, selling high-quality image, could be affected by the dilution of its trademark through AI-generated content. As for damage, the AI mentioned the possibility of recovering actual damage or profit made by stability AI. While this is correct, the AI could have elaborated on the specific types of damages Getty might be entitled to. For instance, statutory damages may be available in certain circumstances, particularly if it can be shown that Stability AI acted willfully in infringing Getty's trademark. The AI could also have discussed the possibility of disgorgement of profit, where the court orders Stability AI to surrender the profit it made from the infringing activity. This will serve as a deterrent and ensure that the defendant does not benefit financially from its unlawful action. In conclusion, while the AI response provides a good foundation, it lacks critical engagement with case law, a deeper analysis of the likelihood of confusion, and a fuller exploration of the defendant's intent. The AI also missed an opportunity to provide a more detailed discussion of the standards for injunctive relief and damage To improve the analysis, the AI could incorporate key case laws such as KT image versus Stability AI, Author School versus Google, and L'Oreal SA versus eBay, which will provide a more comprehensive view of how courts handle trademark infringement in the digital age. Additionally, the AI should delve deeper into the concept of actual confusions and the degree of care exercised by consumers when it comes to AI-generated content. A stronger focus on the elements of bad faith and irreparable harms will also enrich the analysis. This exercise has highlighted how AI-generated responses, while useful, require further refinement to accurately reflect the complexities of legal analysis. My own legal knowledge has been instrumental in identifying gaps and providing a more nuanced interpretation of the law. And this process has underscored the importance of humor critical thinking in legal practice, especially when applying the law to new and evolving technologies. Thank you for watching, and I look forward to any question for feedback you may have.